Can I refuse an offer of accommodation from the council? Now, to be really pedantic, the answer is yes, you can. The council can't force you to accept accommodation. So a better question is going to be, what are the consequences of refusing an offer of accommodation from the council? And the answer to that question is much more complicated, partly because we need to look at the relief and prevention duties and see how they interact. And there's a bunch of other stuff happening as well. Now, I would just kind of put a little caveat in this video to say, this is to the best of my understanding. And the way the law works is so ridiculously convoluted. There's a few bits which I just can't tally up, and I just think they're just genuine problems with the way that the law's been provided. If you look at the code of guidance, there are some chapters which there's quite a few typos. It seems to me that things were a little bit rushed, and basically with the Homelessness Reduction Act in particular, they didn't really think a few things through. As I say, there's a few things that just logically seem impossible to me. But anyway, so just kind of bear that in mind as I go through this. And as I always do with this, I try and give an easy example just to start us off. So let's assume that my house burns down. I'm a British national. I've lived here all my life. So I'm going to be homeless. I'm going to be eligible for assistance, and I'm going to have a priority need automatically. So it's nice and straightforward. And in this situation, I can approach any Department of Local Authority, local housing authority, ask for help with housing and give them reason to believe that I might be homeless. That triggers the homeless application straight away. And in this situation, immediately there will also be reason to believe that I might be homeless, might be eligible, and might have a priority need. So the interim duty to accommodate kicks in. I'm going to talk a little bit more about that in a minute. But basically, the first offer of accommodation is therefore this interim offer, and it is not unusual for that to be many miles away. Very short-term type of accommodation, hotel, B&B, travel lodge, that sort of thing. Could be in an area I've never been to before. So I guess the first question is, what happens if I reject that interim offer? So often the reason people will refuse this offer is because there's something about it which they just don't see as manageable. So it might be that it's just too far away from the kids' school, or your place of employment, or your support network, or it might be just too grimy or whatever. The problem with interim accommodation is you can't challenge the suitability of the accommodation without going to court, so you need a solicitor. It has to go to judicial review. Whereas at other stages of the homeless application process, you can challenge the suitability through the review process. At this interim stage, there is no ability to do that. Now, I have done that without going to court by complaining very loudly to the council, involving councillors, that sort of thing. But legally, there is no way of doing that without going to court. So that's kind of a big problem that we're going to have at the start of the process. So if you were to refuse that offer of interim accommodation, get a solicitor, and the solicitor wins the argument, then that council would have to provide suitable accommodation for you again. There's been loads of court cases around that sort of thing over the years, including councils like Croydon that basically try and say, you know, we have nothing available, and the judges have basically said, tough, you've got a duty to do it, get to it. So that's just the way that works. So you can refuse interim accommodation. Let's use my example. My house is burnt down. I refuse that offer of accommodation because it's just not suitable for me and my family. And let's say I just go and live with my extended family or something, just kind of on a temporary basis. Now, refusing that offer of interim accommodation does not end the homeless application process. So, as we've seen in other videos I've done, the council very quickly are going to be able to be satisfied that I am indeed homeless and I am indeed eligible for assistance, which commences the relief duty, which should only last for 56 days. Lots of councils obviously are going over that time scale by quite some time, and again, all you can do about that is complain or get a solicitor again and do it that way. But on day 57, the council should then issue a decision. Bear in mind, they ended the interim duty because I refused it, and let's say I didn't try to challenge the suitability of it. Day 57 from that relief duty starting, the council should issue a final decision, which, as long as I didn't burn my house down myself, is going to be that I'm owed the main housing duty. And what that means is, basically, they're going to either have to give me a 12-month short hold tenancy, in the private renter sector that is, or an offer of social housing through the housing register. And depending on my circumstances and depending on the local policy, I will get a banding, and I'll often be then in temporary accommodation. So at that point, they need to offer me temporary accommodation this time, it's called technically. It could still be a hotel in the short term anyway, but they would have to kind of make that offer again. But at this stage, I can challenge the suitability of that temporary accommodation without having a solicitor, so going through the review process. It's called Section 202 process, if you want to know that. And lay people can do it. You know, as a lay person myself, I've challenged many things through the Section 202 process. As long as you're right and as long as you kind of cover the main points, it's not that difficult to overturn. Lots of councils will make negative decisions perversely, knowing that most people don't challenge them, and that's kind of how they get away with it. So it's always worth challenging it if you have got a case to kind of put forward. That's what happens if you refuse that interim accommodation. Now, I would also say at this point, there are going to be situations where you can potentially have a more helpful relationship with the council. So let's say, for example, you're fleeing domestic abuse, and the council therefore has an immediate duty to provide interim accommodation. But you could say instead that, you know what, thanks very much for the offer, I feel like I need a refuge right now. The council might refer you to a refuge, or you could self-refer in that circumstance, or maybe another professional could. And then you basically agree with the council to say to them, look, I don't want your interim accommodation. I don't even want you to try and find me interim accommodation. I'm going to be happy with the refuge place, and I want my homeless application process to progress whilst I'm staying in a refuge, whilst I'm getting that support in the refuge, whilst I feel safe. But crucially, that homeless application has been triggered, and you're going to, the council's going to start crunching through that process. And ultimately, again, it's likely you're going to be owed the main housing duty if you get through that relief period without a number of things happening in the meantime, which we're going to come to in a minute. So, as I say, you can, and potentially you could also say to the council, look, my house is burnt down. I know that I'm owed the interim accommodation duty, but instead I'd rather stay with my family, because I think I can make it work, in the short term. And any sensible council will say, fine, that's great. We won't provide you interim accommodation. We've accepted the homeless application. We're going to continue our inquiries. And basically, if your relationship with your family breaks down, come back to us and we'll have that interim duty still to accommodate you. And again, that's what a good council will do. And I've seen Bedford do that a number of times, where they kind of say to that person, look, it's great that you can stay with your family in the short term, but as I say, if that puts a strain on the relationships, do come back to us. And as I say, we've got this kind of safety net of the interim accommodation there for you if you need it. That's the interim accommodation business hopefully wrapped up. There probably are some other permutations that can happen that might kind of give rise to a different outcome. And I might also say on this point that if you break the rules of the interim accommodation, so if you have a party, invite your mates around, get really drunk or whatever, be obnoxious to the hotel manager, they can kick you out, and the council will treat you as if you have rejected that offer of interim accommodation. That's how it kind of works out legally. So that's the interim accommodation duty. Now, let's assume that the interim accommodation the council provides you is okay, so you move into it. And as I say, the council then look at whether you are in fact eligible for assistance, whether you are in fact homeless. And once they're satisfied those two things happen, the relief duty kicks in. A lot of other things happen in the relief duty, but one of the things that the relief duty is really for is to try and find you accommodation so that you don't have to get this main housing duty down the line. It's there for the councils, it's not there for homeless people. This is not better than it used to be, this is worse, but it's what the law is at the moment, so we've got to go with what we've got. And basically, there's two formal offers they can make in this process. And I'm going to do the formal ones first because it kind of makes more sense to do it that way. So the first formal offer is called a final accommodation offer. As I say, it's made in the relief period. It still has to be suitable, but it only needs to be a 6-month assured short hold tenancy rather than the 12-month assured short hold tenancy that you'd get if you waited for the main housing duty. And symmetrically, there's this final Part 6 offer, which again is an offer of Part 6 social housing, but essentially, you don't get the same degree of choice as you would otherwise have if you got through to the main housing duty. And if they tell you in writing, which they should do, if you reject these offers, there will be no further offer made to you under this homeless application process, and then you reject those offers and you don't win the suitability argument with them, that will be the end of the road for you from that council. So you can reject it, but there's a real danger that if you do reject it, you request a suitability review and you lose, that will be the end of the process from that council. And really, you've really cut down your options there. And for that reason, I've said it in other videos as well, you really want to accept those offers of accommodation and then challenge the suitability of those offers afterwards. If you win them, then the council's duties will kick back in to find you something that is suitable. And if you lose it, at least you've got a roof over your head. You still got the same options you'd otherwise have, plus this offer of accommodation, which is going to be probably better than nothing, let's say that much. So that's what happens if you refuse the formal offers. I'm going to group those two things together. Final accommodation offer, final Part 6 offer. There's both these formal offers. And as I say, as long as the council's told you the consequences of rejecting those offers in writing, they've given you time to kind of take it all in, and then you go and reject it, then they can end that process for you and there will be nothing else for you. So this brings us to a really complicated bit, which, as I say, I think I'm getting this right, but it's ridiculously convoluted for no good reason, because there's two things which in the guidance look like they're the same thing. So there's two things in the guidance that look similar, but they're not quite the same thing. And the way it's worded, it's just quite difficult to really get what they're actually trying to say. But I think this is correct. So essentially, as well as making one of those formal offers, now just bear in mind those formal offers, so that the final accommodation offer and the final Part 6 offer has to be a suitable assured short hold tenancy, 6 months tenancy, or a offer of social housing. And that will need to be not with a rogue landlord, kind of all the sort of usual things that would apply to suitability. There's a kind of a higher standard within these formal offers. And if you reject those offers, that's the end of the road. But councils can also make what I'm going to call an informal offer. And that might be, for example, the opportunity to move in with your mum for 6 months or something like that, or it might be an offer of supported accommodation or something like that. Now, so Chapter 14 of the Code of Guidance is basically all about kind of how these relief duties end and how the prevention duty ends. And if you reject that informal offer, so if council say to me, do you know what, there's a YMCA down the road, you're eligible for it, we're going to refer you there, that will be available for you for at least 6 months, so it'll be a discharge of this duty. If I said to them, no thanks, I don't like the YMCA, thanks, I want my own front door, I don't want to have an unaffordable thing, I want to work, I don't want to have to pay ridiculous rent costs or whatever, there is no consequence on the main housing duty of me refusing that informal offer. As I say, different from those formal offers of the final accommodation offer and the final Part 6 offer. So there is no penalty on that main housing duty. And because my house has burnt down and therefore I know full well I'm in priority need, I'm homeless, I'm eligible, for me it's a safe bet to say no thanks to the YMCA, and instead the relief duty will end. They'll then issue a final Section 184 decision, which will be, Mike, you owed the main housing duty, and then I'm going to be able to get one of those two options. So the 12-month short tenancy in the private renter sector, or onto the housing register with a fairly high banding, which will enable me to get housed at some point in the future. And if you're outside London, that's probably going to be 6 or 12 months most likely. If you're in London, it could be many years. That's just the way it is, unfortunately. So that's what happens if you refuse those informal offers. But note, the relief duty does end. So if you're not in priority need, this is where the real difficulty comes in. So if, for example, you've got mental health issues, you think you're in priority need, but it's not a dead cert, this makes it very difficult to actually reach that decision or make that decision, because you don't have the full facts in front of you. You don't know what's going to happen to that final, you don't know what's going to happen to that main housing duty if you refuse this informal offer, because the relief duty could end and then the council could be horrible and basically issue a not in priority need decision. Now you can obviously challenge that, as I've said elsewhere on the channel, so it is not difficult to challenge it, but it is extra stress, it is extra work to do. And so for that reason, people are going to probably be more likely to say, well, do you know what, I'll take that YMCA rather than kind of hold on for the main housing duty, because a bird in hand is worth two in the bush, that kind of logic. And that's sound logic, given that you don't know what you need to know to actually make that decision. So I would argue that council should actually tell you whether you're likely to be found in priority need, but they're almost, they're very likely to say you're not in priority need even if they think you are, because again, it just kind of puts you into this sort of situation where you just feel like you need to accept the first offer that comes up. So that's what can happen with the informal offer. So it has no bearing on that main housing duty if it's going to be owed to you. But if you're not in priority need, if you refuse that offer of YMCA or whatever, that's the end of the road. That's the end of the relief duty, and the council doesn't have to do anything more for you. Now, do bear in mind with that, I'd say, is that there's nothing stopping you applying for that YMCA directly. So there's nothing stopping you, as well as the council trying to refer you there, you can self-refer often to these projects, and you can even basically have a conversation with that YMCA first and basically say, look, I'm holding out for the main housing duty. If I don't get it, can you basically allow me to be top of the list or whatever, however it would work. And I've done that in Bedford with supported accommodation, where I've explained that situation to them and said, look, this guy is likely to be found in priority need, he's not intentionally homeless, he's probably going to be owed the main housing duty, but just in case he's not, can you just keep him at the top of your list just in case that falls through? And those situations, that the supported accommodation are totally happy with that. The final confusing thing that can happen here, and if I just go back a step very quickly, those informal offers could be rogue landlords. Councils do use rogue landlords. They would say that, well, who else are we supposed to use? Where else are we supposed to put our homeless people? I would argue that by colluding with that kind of whole corrupt system, you're just perpetuating the fact that rogue landlords exist. But anyway, that's another video there. And finally, there's another thing that can kick in here, and that is the council say that you've basically deliberately and unreasonably refused to cooperate with the personalised housing plan, which is kind of all part and parcel of the relief duty. And the sorts of situations that I think they're thinking of there, and I've not seen it myself in my own casework, but I think the sort of situations they're kind of thinking there is that where you don't formally reject an offer. So, the council says, we've got this offer of suitable accommodation for you, and instead of just flatly saying, no, I don't want it, you instead just don't turn up to the sign up, or, you just go silent, or, you just don't engage with that process. Apparently, I've heard, secondhand that council officers will sometimes use it, because where they say, you need to go out and find private rented accommodation for yourself, and then the applicant simply just doesn't engage with that process. Again, they might go down the line of saying that you've deliberately unreasonably refused to cooperate. Now, again, to issue that decision that you have been uncooperative, they have to go through several steps in terms of writing to you and giving you notice and all that sort of thing. But let's say they do that, it has this final kicker that would end the relief duty. But if you're then owed the main housing duty, or you would be, so my house is burnt down, didn't set the fire myself, I'm eligible, blah blah blah, so I'm going to be owed the main housing duty. They offer me some ramshackle rogue landlord private accommodation. I don't, strictly speaking, turn it down. I just don't pick up the phone to them, and I don't go out looking for my own private rented accommodation, because I'm sitting there pretty easy thinking I'm going to be owed the main housing duty if I don't engage with this process. They can then basically say that I've unreasonably and deliberately refused to cooperate. And then essentially the relief duty ends, and the council then has this Section 184 decision to make. But whereas I'd otherwise be owed the main housing duty because I'm homeless, eligible, in priority need, not intentionally homeless, and local connection is kind of not an issue, let's say, that instead of giving me that main housing duty, which is the 12-month assured short tenancy or the place on the housing register, kind of in layman's terms, they would instead drop me back to a final accommodation offer or a final Part 6 offer. If you remember, those are lesser housing duties, so it's only a 6-month assured short hold tenancy. It's only a direct offer of social housing rather than being able to bid on properties on the housing register. I guess with that, I'd say some councils don't even appear to allow anyone to bid on properties, but that's another issue entirely. But they would potentially use that to kind of give you that watered down version of the main housing duty. And so there probably are other situations where you might kind of have that question of, do I refuse accommodation? Again, just to reiterate, if you're going to refuse accommodation, you need to have a backup plan. And if you don't, just bear in mind that the council can literally end that duty, and that is it. It's very difficult then to approach that local authority again for there to be a duty to house you in any other circumstances. So you need to take legal advice if you can get legal advice at that point. But you can, there are situations where you can turn down accommodation offers, as I say, if it's an informal offer, where it is a really kind of ramshackle offer, and you're going to be owed the main housing duty, then you could turn it down and the main housing duty would still potentially apply, if you hit the tests. You can deliberately unreasonably refuse to cooperate, but you would not get the main housing duty as it normally is. Instead, you get this lesser duty. And you might also find that once you get to that final stage, this is probably the last thing I can think of at this moment. So let's say you get through the relief period, you get that Section 184 decision as kind of accepted, they owe you the main housing duty. There is still nothing stopping that council offering you other types of accommodation. So they still could, at that point, offer you a referral to the YMCA. They could say, yeah, Mike, you're owed the main housing duty, blah, blah, blah. But what about the YMCA? Look at all this support you get. It's brilliant there. Look at how nice it is there. It's, psychologically informed environment. There's nice kind of decor and stuff like that. They can make it sound as nice as they want to, but it's not a substitute for the main housing duty. So, if you're owed that main housing duty, it's only going to be discharged for a 12-month assured short hold tenancy in the private rented sector or a Part 6 offer through the housing register. But they may well try and sweeten the deal and try and make it look like, you kind of get something better than that. I would say in pretty much every circumstance, certainly if for myself, what I would say is I would turn down those other offers. The main housing duty is the best offer you're going to get in terms of security of tenure, probably in terms of suitability and cost and things like that. So if you're working, it's going to be much more viable to actually pay for it, or even saying that, in the private rented sector is still probably going to be quite tough. But that's going to be your better, that's going to be your better option, because just kind of bear in mind, if you were, let's say you had some real kind of difficulties going on, you're struggling with mental health or something, and you have a mental health breakdown, you don't kind of pay the rent or whatever it might be, you get into difficult situations. Let's set aside intentional homelessness for a minute. If you're then evicted from that secure offer of accommodation, so a 12-month short tenancy or social housing, you can still go to the YMCA. Whereas if you get evicted from the YMCA for breaking the rules or something, you're probably going to be intentionally homeless, and therefore you're not going to be able to get those best options through the council's homeless application process. So I'm hoping you're not totally confused by all that. I may well try and record this video again if questions come in and I haven't made sense. But basically, if you look through chapter 14, in fact, I'll probably put a few bits of the code of guidance on the screen as I went through there, just to kind of say how it, trying to cement how it all works. But it is something which is really complicated. There's a few things I haven't introduced, which are the things which I think don't make sense at all, which kind of come down to the quality of accommodation offered. I'm not even going to try and explain what I think it's meant to mean when it says that in the guidance, but I'm pretty sure what I've just said there is solid. don't take my word for it, this is not legal advice. I'm doing my best here to try and explain this stuff. But if you're in that situation yourself, one of the things you can do is you can basically insist that the council housing officer puts everything to you in writing, because under section, I think it's 179 of the Housing Act, councils have a duty to provide advice and assistance free of charge. And that would include laying out your options, because I think, housing officers are under this pressure to basically get rid of you, and the ones who don't have morals will basically, kind of beg, borrow and steal to kind of get rid of you, and they'll trick you, and they'll try and, kind of lead you up the garden path with offers of accommodation which actually aren't quite what they seemed in the first instance. I've worked with a number of people who were kind of in that sort of situation, and the council said, oh, we've got a complex needs unit, it's brilliant, it's brand new, it's so good. And then on day 2, they're like really, really regretting taking up that offer, because it's just had this massive implication on their kind of their future housing. And so councils really do need to lay out in writing, in a digestible form, not with lots of legalese, what these different options entail and what the consequences are of you accepting them or refusing them. And you probably want to get independent advice at that point, because bottom line is I don't trust housing officers to actually really tell you what's going on. They'll always try and make it sound appealing, or more appealing than it probably is, to take options which help them out by basically getting you off their books. And as I say, you shouldn't be criticised for looking to act in the interests of yourself and your family. That we have a rights-based system in the UK. If council officers don't like that, they need to basically, lobby the government to repeal those rights. But for the time being, we have those rights. We shouldn't have to defend ourselves or justify ourselves when we want to be treated according to our rights under housing laws. So yeah, if you've got any questions, put them in the comments, and as always, I'll answer them, or we'll try our best to answer them in the weekly live stream on a Thursday night. It's recorded, so you don't have to watch it live. But I'm hoping this has been helpful to some level. As I say, I might end up recording it again at some point, just to maybe do a better job of it. But I'm hoping it will be something. I'm hoping it's better than nothing, basically.